Donald Trump walks into this Super Tuesday with his name on all respective ballots and a legal win under his belt after the Supreme Court ruled states could not remove him from the ballot for violating the 14th Amendment. And this morning, there's fresh fallout from that decision. New concern it could dampen the ability of lawmakers to rein in insurrectionist candidates, potentially setting significant limitations that reach beyond the states to Congress. And joining us with more on this, MSNBC legal correspondent Lisa Rubin and former federal prosecutor Renato Mariotti. Great to have you both here. So, Lisa, some interpretations of this decision suggest even Congress has a narrow path when it comes to enforcing the 14th Amendment. So just how restricting is this ruling when it comes to keeping insurrectionists out of office?
I think that remains to be seen, Anna. And one of the concerns is that the Supreme Court, even though they say only Congress can implement Section 3 of the 14th Amendment, is imprecise in how they're supposed to do that. They say that they can only enact remedial legislation and that they're supposed to do so narrowly. But the concern is that we could be back before the court with respect to later efforts to disqualify either particular candidates or categories of candidates. For example, people who have been convicted of crimes related to January 6th. Is that narrow enough for this court? We don't know yet.
So help me understand, though, if they're saying, yes, Congress has the power to do this, how is Congress's hands tied?
Well, I think the question is, how narrowly does such remedial legislation need to be drawn?
What does that remedial legislation mean?
Well, that's part of the question.
Yeah.
Like, if you have somebody who is an insurrectionist, need they be found guilty in a criminal court to have remedial legislation? Does that remedial legislation need to be very, very specific as to a particular person? Or can they enact remedial legislation with respect to categories of people, as I just posed, people who have been convicted of certain crimes related to their participation in January 6th? And we just don't know how narrowly the court will cut that. There are concerns that we will be in cycles of litigation for years to come to the extent that Congress chooses to enforce its powers under Section 3 of the 14th Amendment now.
Trump has been praising this Supreme Court decision. Yesterday it seemed he was expressing confidence about how the high court might handle his presidential immunity argument that's to come. Listen.
So we had a great day with the Supreme Court. That was a great win for America. I was really very proud of it. And now, hopefully, on immunity, which is a big one coming up, because you can't take the power away from the president.
Renato, did the justices give any clues on the immunity question?
They did give one clue in the question presented to the Supreme Court. So there were a number of arguments that were made by Trump. Some of them, as I think has been discussed on this network and in this program before, have been fairly absurd, right? These sort of very wide-ranging immunity arguments that Trump could do anything and not be prosecuted for it. And the Supreme Court took up a narrow issue, whether and to what extent there is immunity for acts that are alleged to be official acts that were undertaken during the course of the presidency. And I think that's important because it sort of hints at the fact that the Supreme Court might split the baby, so to speak, and have a ruling where you end up having a small, narrow presidential immunity that does not cover what Trump did, but nonetheless provides a reason to not only have an oral argument and a decision, which we know is coming, but potentially a remand to Judge Chutkan that runs some time off the clock, in which she has to make a finding that the actions by Trump that are alleged in the indictment fall outside that very narrow presidential immunity.
So I want to turn now to Trump's Georgia election interference case because new developments there. One of the co-defendants of Trump's is seeking to enter new testimony where he claims that he would reveal a witness lied about the timeline of DA Fani Willis's relationship with her special prosecutor, Nathan Wade. Lisa, do you expect the judge will allow new testimony on this issue? And just how long could this drag out?
I don't think so, particularly given how many new pieces of evidence folks want to introduce here on both sides. The state, for example, wants to introduce testimony from a winery employee who recalls Willis and Wade visiting and Willis paying in cash. The submission yesterday is from a friend of Terrence Bradley's who recalls him telling her when the relationship began, but also overhearing him on the phone with Fani Willis. I think we've reached a place of sort of preposterousness now that the evidence has closed, with everybody trying to get something in under the wire before McAfee rules, with the exception of the cell phone records, which I think he might be inclined to take a look at. I don't really see him opening up the evidence wide to hear from all of these extraneous figures and what has become a really sordid drama, Anna.
And it continues to delay, again, proceedings in
Correct.
that particular case. The one that seems to be on fast track is what's happening in New York. Trump's criminal trial for the hush money payments set to get underway in just a couple of weeks now. Trump's team, though, is now claiming Manhattan DA Alvin Bragg is treating two witnesses who've admitted to lying under oath in the past, Michael Cohen and Alan Weisselberg, differently. The Trump team saying Cohen's getting better treatment because he's willing to turn on Trump. Renata, what's your read on this? Is this prosecutorial misconduct, as Trump's team claims, or is this just to be expected leverage? Is how it works?
I think it's neither. I actually think it's a spin by Trump's team. I think partly they're hoping to get us talking about it like we are right now. I think partly it's to just throw some shade on the prosecutor. I mean, ultimately, the prosecution is going to put on its witnesses on the stand. They're going to be cross-examined. And it's not unusual for prosecutors to put cooperators on the stand who have issues. Often they're convicted of crime. Often they're convicted of crimes like fraud and dishonesty, like Michael Cohen is. And so ultimately, the jury will have to weigh his credibility. That's not all that unusual. But of course, by making a big showing of it, it creates discussion. It probably creates, talking points or fodder for disinformation, and it also, furthers the narrative.
Well, thank you for setting it all straight for us. As somebody who has experience with these cases, Renato Mariotti and Lisa Rubin, good to have you both here. Thank you.